Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibiers? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Not on camera today because, I'm going to be honest, I didn't feel like putting makeup on. We are going to catch up on some filings in Charlie Adelson and Donna's case. We're going to jump right in. His appellate attorneys have replied to the state's response to appellate's motion to relinquish jurisdiction to the trial court. Just an FYI, you're going to hear Giglio and Brady in the filing. So what are these? Brady violation is violating due process by not disclosing exculpatory evidence. Failing to do so violates due process. If you followed the Alec Baldwin trial for the Rust onset shooting, his case was dismissed due to a Brady violation. And Giglio is the prosecution is obligated to disclose all information or materials that may be used to impeach the credibility of prosecution witnesses. So let's read this filing. It says, simply put, it is better to address this issue now because the conflict claim was just considered by the trial court in Donna's case. In a footnote, it says it's better to have Judge Everett consider this issue now than risk the possibility of a different judge having to consider this issue in the future. Otherwise, this conflict issue will continue to cloud Charlie's case for many months or years to come. Notably, there's no harm to the state if the issue is considered now. The footnote says that if the court relinquishes jurisdiction to the trial court, the state would be permitted to raise all of the arguments set forth in their response, and both parties would get finality on the issue. It's in the interests of both justice and judicial economy for the issue to be considered now. The procedure articulated by the Florida Supreme Court in State v. Menendez allows relinquishment in particular cases when it's better that an issue be resolved sooner than later. The conflict issue in the instant case clearly fits into this category. As explained in the motion to relinquish jurisdiction to the trial court, this court recently followed the procedures set forth in Ferguson v. State as demonstrated by the court's December 30th, 2020 order in that case. In Ferguson, while Mr. Ferguson's case was pending on direct appeal, Mr. Ferguson filed a motion to relinquish to the trial court so that the trial court could consider his Giglio Brady claim, and this court granted Mr. Ferguson's motion to relinquish. Thereafter, Mr. Ferguson filed a motion in the trial court raising the Giglio Brady claim, and the trial court set the matter for an evidentiary hearing. Following the evidentiary hearing, the trial court granted relief on the Giglio Brady claim, which made the direct appeal moot because the trial court vacated Mr. Ferguson's conviction. In response, the state asserts the issue in Menendez was a Brady violation, and the state argues that a Brady claim is somehow procedurally distinguishable from the conflict in the instant case. Contrary to the state's assertion, the claims raised in Menendez and Ferguson are procedurally indistinguishable from the claim raised in the instant case. The claims in all three cases concern the denial of fundamental constitutional rights, i.e., the right of due process in Menendez and Ferguson, and the Sixth Amendment right to conflict-free counsel in the instant case. In its response, the state raises several factual assertions, and then the state makes legal arguments based on these factual assertions. However, these factual assertions and legal arguments are properly considered by the trial court following an evidentiary hearing. Accordingly, Charlie requests the court temporarily relinquish jurisdiction to the trial court so the trial court can resolve his conflict of interest claim. It is most efficient to address this issue now because undersigned counsel have a good faith basis to believe that Charlie is currently serving a life sentence after being unconstitutionally convicted without the benefit of conflict-free counsel, which is akin to having no counsel at all. Contrary to the state's assertion in its response, the conflict issue is certainly not frivolous, especially in light of Judge Everett's recent conflict order in Donna's case. As explained by the U.S. Supreme Court in Brady, society wins not only when the guilty are convicted, but when criminal trials are fair. So that was the end of their response to the state's response. No rulings yet. We'll see what happens. I'll keep an eye out on the court website to see if anything's filed. There is a new filing for Donna because she has a new attorney, Josh Zellman. And the judge is not taking any chances. There was an order filed by the judge for the new attorneys to perform a comprehensive conflict of interest check as it pertains to prior representation of co-conspirators, co-defendants, or witnesses in this case or related manner. There is a hearing set for December 10th, and the judge wants the attorney prepared to fully address all conflict of interest issues or certify representation of Donna will be conflict-free. So that's the latest in Adelson world. Charlie's birthday was earlier this week, I think Monday. Two of his exes, the mother of his child and June, who testified at his trial, both put some pretty loving posts up on social media for Charlie Boy. Moving on to the Menendez brothers. They are all the talk in the true crime world right now. The Los Angeles District Attorney George Gascon recommended resentencing and recommended they be resentenced for murder, which is 50 years to life. That was sent to the Van Nuys courthouse Friday and transferred again yesterday to Superior Court. Now, if the judge reduces the sentence, the brothers would be eligible for immediate release due to the fact they were under 26 years old at the time of the murders. And at this point, and they've served over 25 years at this point, actually 35 years. The DA listed the good deeds and progress the brothers have made in prison over the last 3.5 decades. Also, their attorney, Mark Garagos, said if resentencing takes place, he plans to ask the court to recall their murder conviction and ask for that lesser charge of voluntary manslaughter. The maximum sentence for that is 11 years, so they would have served well over that and could be freed immediately with no parole, no conditions. So what happens now? A judge will review the request and can go with the DA's recommendation, which would pave the way for their release, denied altogether. Or the judge could choose one that he thinks is appropriate. From there, it would go to the parole board. If the parole board agrees with the judge, the final decision would come from California Governor Gavin Newsom. Just last night, the Menendez brothers' attorney Mark Garagos was on Banfield and said he'll be asking Governor Newsom for clemency. Newsom recently said on a podcast that governors are typically really busy around Thanksgiving, working on pardons and clemency. Mr. Garagos said he will submit an application asking the governor to consider clemency. If freed, they would not be eligible, by the way, to spend any money that is left from their parents due to state law. So we will see and keep you posted. Sounds like we might know something soon on this. Moving on to Kouri Richins. She's asking to be let out on bail again. Her trial has been delayed until April next year. And in the appeal, her attorney says at the time of the original detention hearing in June of 2023, it was believed that preliminary hearing and trial were imminent. Based on the newly scheduled trial date, if Ms. Richins is not released, she will have served 2 years in jail at the time of her trial, all while presumed to be innocent. The appeal goes on to talk about the things she's done that are good while she's in jail. Participating in classes, and volunteers say she is positive and resolute. The appeal goes on to say the court can now take that pattern of positive behavior into consideration in determining whether conditions can be set that ensure the safety of the community. Her attorney also says that her being in jail has caused irreparable damage to her relationship with her sons, saying that they think of her now as a distant relative. This forced separation and emotional estrangement from her children is causing Mrs. Richins extreme emotional distress during a time that she is presumed to be innocent under the law. If she were to be released, she could participate in supervised in-person visits and try to repair some of the damage that has been done to her relationship with her sons before it's too late. Her attorney says that she could live with her brother and sister-in-law in Salt Lake County to remove any risk of inadvertent interactions with possible witnesses in the case. Ms. Richins' family is prepared to provide essentials such as food, clothing, and educational resources and they are committed to making sure that she appears at all court proceedings as required. The family members are prepared to discuss these commitments with the court at a new detention hearing. Don't think that will happen, but we will see. So that's it for today. Just updating a few things. I'm going to take some time tomorrow and just make it a family day for Halloween. But I will see you on Friday with a new episode. In the meantime, hope you guys have a good rest of your afternoon, and we will see you soon.